In a consolidated case, a member of the Board of Trustees and Legal Counsel of the Iral Muslim Youth Foundation received a 200 million donation from a senator. He then gave it to the treasurer of the foundation, who then in turn deposited the said amount to the foundation's bank. The donor senator, together with the ombudsman, publicly accused a certain Philippine president, including the said member of the foundation, of plunder, under Republic Act No. 7080, or the Act defining and penalizing the crime of plunder, as amended by Republic Act No. 7659. One of the issues raised was whether or not the Sandigan Bayan, by issuing a resolution finding probable cause to justify the issuance of a warrant of arrest for the accused, violated due process of law. The Supreme Court ruled that the right to preliminary investigation is not a constitutional right, but it is a right conferred by a statute. Petitioner was given the opportunity to answer the charges against him during the preliminary investigation. Jurisprudence dictates that courts do not interfere with the discretion of the ombudsman in its conduct of preliminary investigation. It was enunciated in Raro v. Sandigan Bayan that in the performance of the task to determine probable cause, the ombudsman's discretion is paramount. The lack of preliminary investigation does not impair the validity of information filed before the court. Hi, I pray everyone of good health. This is Icicle once again, and I will be reporter for the 4th episode of Philippine Laws Dissected. In the deliberation of the restoration of death penalty in the Philippines, plunder was enumerated as one of the crimes punishable. Many lawmakers say that this would help avert corruption of government funds. However, others still stress the need to amend and to improve this law, as there are many loopholes in successfully prosecuting a person under this law. To start off this episode, let us first delve into why this law came into existence. In the aftermath of the Marcos dictatorship, the then President Ferdinand Marcos, his wife Imelda, and their cronies had allegedly amassed ill-gotten wealth. The Philippine government, following the 1986 revolution, found that these existing laws were clearly inadequate to cope with the magnitude of the corruption and thievery committed during the Marcos years. This opted for the filing of anti-plunder bills, led by the then Senator Jovito Salonga in the Senate and by the then Representative Lorna Yap in the House of Representatives during the 9th Congress. These bills were consolidated to form Republic Act No. 7080, signed by the then President Corazon Aquino in 1991. Plunder, in its first enactment by way of Republic Act No. 7080, had already gone a long way. At present, it is now amended by Republic Act No. 7659. So what is plunder under this amended act? Under Republic Act 7659, Section 12 states that plunder is done by any public officer who by himself or in connivance with members of his family, relatives by affinity or consanguinity, business associates, subordinates or other persons, amasses, accumulates, or acquires ill-gotten wealth through a combination or series of overt criminal acts, as described in Section 1D in the aggregate amount or total value of at least 50 million pesos. As such, in order for a person to be convicted of the crime of plunder, the following elements should then be present. First, that the offender is a public officer. Second, he acted by himself or in connivance with members of his family, relatives by affinity or consanguinity, business associates, subordinates, or other persons. Third, that the aggregate amount or total value of the ill-gotten wealth amassed, accumulated, or acquired is at least 50 million pesos. Fourth, that he amassed, accumulated, or acquired ill-gotten wealth through a combination or series of the following overt or criminal acts enumerated under Section 1, Paragraph D. Who can be held liable under this law? A person may be held accountable under this law if he is a public officer who committed the act of plunder, and of course, those who connive with the said public officer in the commission of an offense contributing to the crime of plunder. Provided that the possible offenders under this law are public officers, they have benefits that were once attached to their original position. There is a provision under this law that provides for the suspension and loss of these benefits once these public officers committed the act of plunder. Under Section 5, it specifically mentions three possible scenarios. First, when these public officials have pending cases in court, they are to be suspended from public office. Second, when these public officials are convicted by final judgment, they lose all retirement or gratuity benefits under any law. And lastly, when these public officials are acquitted, they are reinstated from their position and is paid for salaries and other benefits he failed to receive during suspension, unless administrative proceedings have been filed against him. In order to fully understand the parameters of this law, it is important to know how we should understand specific words and provision under this law. As such, under this segment of this episode, we will dissect how these terms should be understood within the purview of the law. Section 12 of the amended law mentioned the phrase in connivance. In this case, how should we construe the term in connivance? Under the separate opinion of Justice Vitog, he states that the term in connivance would suggest an agreement or consent to commit an unlawful act or deed with or by another to connive being to cooperate secretly or privately with another. The amended information alleged connivance and would assume that petitioner and his co-accused had a common design in perpetrating the violations complained of constitutive of plunder. Let us put this into perspective. Let's say Gingestra illegally gambled a huge sum of money. Mr. Umbuds accused Gingestra that the gambled money came from government funds, plundered by his father Josestra, who was a public officer. Now, there are several cases filed against Josestra. Thus, the illegal gambling of Gingestra constitutes a series or combination of overt or criminal acts as required in Republic Act No. 7080. Should Gingestra be tried together with Josestra for conspiracy of plunder? What do you think? The answer is no. In the case of Jose Jingoy Estrada versus Sandigan Bayan with GR number 148965, February 26, 2002, the Supreme Court held that while it is clear that all the accused named in subparagraphs A to D through their individual acts conspired with the former President Estrada to enable the latter to amass, accumulate, or acquire ill-gotten wealth in the aggregate amount of 4,097,804,173.17 pesos as the amended information is worded. However, it is not certain whether the accused persons named in subparagraphs A to D conspired with each other to enable the former president to amass the subject ill-gotten wealth. In view of the lack of clarity in the information, the court held petitioner Jose Jingoy Estrada cannot be penalized for the conspiracy entered into by the other accused with the former president, as related in the second paragraph of the amended information in relation to its subparagraphs B to D. Instead, the petitioner can be held accountable only for the predicate acts that he allegedly committed as related in paragraphs A of the amended information, which were allegedly done in conspiracy with the former president, whose design was to amass ill-gotten wealth amounting to more than 4 billion pesos. On another note, the law also mentions the word ill-gotten wealth. But what exactly entails ill-gotten wealth? Under Section 1D, ill-gotten wealth is defined as any asset, property, business enterprise, or material possession of any persons within the purview of Section 2 hereof, acquired by him directly or indirectly through dummies, nominees, agents, subordinates, and/or business associates. This can be done first through misappropriation, conversion, misuse, or malservation of public funds or raised on the public treasury. Second, by receiving directly or indirectly any commission, gift, share, percentage, kickbacks, or any other form of pecuniary benefit from any person and/or entity in connection with any government contract or project, or by reason of the office or position of the public officer concerned. Third, by illegal or fraudulent conveyance or disposition of assets belonging to the national government or any of its subdivisions, agencies, or instrumentalities or government-owned or controlled corporation and their subsidiaries. Fourth, by obtaining, receiving, or accepting directly or indirectly any shares of stock, equity, or any other form of interest or participation, including the promise of future employment in any business enterprise or undertaking. Fifth, by establishing agricultural, industrial, or commercial monopolies or other combination and/or implementation of decrees and orders intended to benefit particular persons or special interests. 6. By taking undue advantage of official position, authority, relationship, connection, and influence to unjustly enrich himself or themselves at the expense and to the damage and prejudice of the Filipino people and the Republic of the Philippines. In addition to connivance and ill-gotten wealth, there are also several terms under Section 1, Paragraph D that should be construed in accordance with the intention of the law. It is explicit in the case of Estrada v. Sandigan Bayan with GR number 148560, November 19, 2001, that these terms are intended by Congress to be understood in their popular meanings. This is evident from the legislative deliberation on the bill, which eventually became Republic Act number 7080 or the Plunder Law. When the Plunder Law speaks of combination, it is referring to at least two acts falling under different categories of enumeration provided in Section 1, Paragraph D. Examples of which is raids on the public treasury in Section 1, Paragraph D, subparagraph 1, and fraudulent conveyance of assets belonging to the national government under Section 1, Paragraph D, subparagraph 3. Series must be two or more overt or criminal acts falling under the same category of enumeration found in Section 1, Paragraph D. Lastly, pattern is sufficiently defined in Section 4 in relation to Section 1, Paragraph D, and Section 2 of the Plunder Law. Now that we know how and when can a person be held liable for the crime of plunder, it is also important to know what are the corresponding penalties under this law. Under existing laws, the public officer is punished by reclusion perpetua to death. This penalty also extends to any person who participated with the said public officer in the commission of the crime of plunder. In the imposition of penalties, the degree of participation and the attendance of mitigating and extenuating circumstances as provided by the revised penal code shall be considered by the court. The court shall declare any and all ill-gotten wealth, and their interests and other incomes and assets, including the properties and shares of stocks, derived from deposit or investment thereof, forfeited in favor of the state. In criminal cases, the identification of mens rea is important in the prosecution of the offense. What is then mens rea? Mens rea pertains to a person's awareness of the fact that his or her conduct is criminal. In the case of plunder, a person's conduct is considered to be criminal if first, he must willfully, unlawfully, and criminally amass ill-gotten wealth, Or, second, he must willfully, unlawfully, or criminally join with the rest of the accused to amass ill-gotten wealth. It should be taken note that plunder is malum in se, requiring criminal intent, precisely because the constitutive crimes are mala in se. The elements of mens rea must be proven in a prosecution for plunder. It is noteworthy that the amended information alleges that the crime was committed willfully, unlawfully, and criminally. It thus alleges guilty knowledge on the part of the accused. Now imagine this. A person comes to you for help. He wants to file a case for plunder against certain people who he thinks conspired with each other. He is asking you if there is a need to provide evidence for each and every act of these persons involved. What would be your advice? Well, it should be known that it is not necessary to prove each and every criminal act done by the accused in the furtherance of the scheme or conspiracy to amass, accumulate, or acquire ill-gotten wealth. It being sufficient to establish beyond reasonable doubt a pattern of overt or criminal acts indicative of the overall unlawful scheme or conspiracy. Now that we know the substantive details of this law, we will now talk about the technicalities we should know about this law, which are jurisdiction and prescription. First is jurisdiction. As previously mentioned in one of our videos, prosecution of these offenses are lodged in which Philippine courts have jurisdiction of the said crime or offense. In the case of plunder, all prosecutions of the crime are within the original jurisdiction of the Sandigan Bayan, unless otherwise provided by law provided in Section 3. Which now leads us to a question as to what is the prescription period for the prosecution of plunder. As to the prescription, the crime of plunder will prescribe in 20 years. However, such prescription does not include the right to recover properties unlawfully acquired by public officers from them or from their nominees or transferees provided in Section 6. The first ever plunder cases were filed on August 15, 1997 against Dominga Manalili and 6 others for taking advantage of their official positions as employees of the Bureau of Internal Revenue, unlawfully and criminally amassing and acquiring funds belonging to the national government. Manalili became the first person to be convicted of plunder in the Philippines. She was sentenced by Quezon City Regional Trial Court Judge, now Supreme Court Associate Justice Diosdado Peralta, to 2 life terms and was ordered to return the money she stole plus all profits earned. The filing of the first plunder charge was somewhat encouraging, but as the years passed, the result lent validity to the view that there is a double standard of justice at work in these isles of gross inequality and worse injustice. This is why many public officers can get away with plunder. This poses the need to assess and re-evaluate the current plunder law and determine the loopholes of its provision. But will a masked man reveal his true face intentionally and voluntarily? We will never know. This ends our episode for today. I hope you learned a lot. Stay safe and stay at home. Till next episode of the Philippine Laws Dissected.